Mr. Smith, possibility for a short rebuttal.
Thank you. I know it's late, so I will be brief. Yeah, I just first want to quickly correct a couple of factual misstatements that were made. El Salvador did not request that the United States issue any specific sort of non-disputing party submission in this case. It's true, obviously, that El Salvador consulted with the other party and invited them to make a decision, but it certainly wasn't a request to make a particular type of decision, and El Salvador was perfectly ready to have them put in a submission that was contrary to El Salvador. It is equally true that their decision not to make a submission in no way infers that their position has changed, and there was not some sort of a competition between the parties to see if they could get the U.S. to submit, and since they didn't, somehow the U.S. now supports the position of the claimants. But again, I can't speak for the U.S. The other point of fact is that the law firm of Dewey & LaBeouf does not represent Nicaragua and does not represent Costa Rica. In fact, our law firm has been adverse to Costa Rica in an recent ICSID case in Ungalube versus Costa Rica. So I wanted to clarify those facts. Another issue that was raised that I think needs brief clarification is whether somehow El Salvador had forced claimants into some sort of a situation where they were going to be faced with a statute of limitations, and somehow El Salvador is to blame for the fact that they couldn't act in conformity with their waivers. There's a couple of things. First, claimant was at liberty at any time to act in conformity with their waivers, but even if we look to the point where El Salvador brought the issue to their attention, they were still at least a little over 2 months away from the running of the statute of limitations, because El Salvador has been very clear that the 3-year period in CAFTA runs not from the date of a particular act, but from the date on which the possible claimant becomes aware of the act and aware of those damages. That date was September 13th, 2006, when the revocation of the environmental permits was notified to the claimants, and therefore the date of the running of the statute of limitations would have been September 13th, 2009. They had plenty of time from the time they filed their case until that date to withdraw this proceeding, seek termination of the proceedings in El Salvador, and then refile a new case, but they chose not to do that. It was not El Salvador's obligation to tell them that they should have done that or invite them to do that. As regards the joint venture, the issue of the relationship between Commerce, San Sebastian Gold Mines, and the Commerce San Sub joint venture, they've now taken the position that San Sebastian Gold Mines is an independent investor and is making their claims based on their investments, that is based on their percentage participation in the joint venture. That's not the way that they pleaded this case. They pleaded this case as if they had independent rights, independent of the joint venture. But more importantly, under their new representation of the facts, where Commerce Group is a holder of all of the interests, the recipient of the environmental permits, the holder of the concession, and the recipient of the revocation of the environmental permits, not only does San Sebastian Gold Mines have no interest and no claim in El Salvador, the joint venture doesn't either. It would only be Commerce. So again, they're still in the same position of having to choose between either they have no claims because they were not involved, or they were a part of the proceedings and they violated their waivers. They can't have it both ways, but they keep trying to have it both ways. I also just want to point out there's been a considerable discussion of whether or not the waiver applies to the investment law proceedings regarding the investment law before this tribunal. You've heard the positions of the parties. From El Salvador's point of view, that issue is not yet ripe for decision. It has not been placed before the tribunal. El Salvador, again, reserves its right to raise that issue if the time came, but would hope that the tribunal would reserve a decision on that until it has been fully briefed, as it is a rather significant and complicated legal issue. And finally, with regard to the issue of whether or not El Salvador could have taken the waiver to the Supreme Court of El Salvador and sought the termination of the case. They've said that the Attorney General's opinion submitted in response to the tribunal's question did not address that issue. Of course, it didn't address that issue. It was in response to an entirely different question. However, the case that was submitted along with that, with the respondent's submission, one of the two Supreme Court cases clearly states that the only way for a termination under Article 40 by a party is for the claimant itself or a representative of the claimant to request in writing to the tribunal for discontinuance. So while claimants may not have their own separate knowledge of this issue under Salvadoran law, I don't think they've put forward anything to challenge that position. And just finally, to read it, in this regard, this chamber clarifies that the ground for discontinuance provided for in Article 40, letter B of the law of administrative litigation jurisdiction is an integral part of the right of a petition that every citizen has when appearing before the judicial body. Such expression is a concrete character, just as a claim filed in writing and admitted by this tribunal indicates the beginning of the process. The discontinuance is the concrete expression by the claimant in writing before this tribunal that it does not intend to continue with the proceeding. And just one final point. Claimants Counsel has said that it is not their position that the waiver requires them to do nothing. But that is exactly what Claimants Counsel has claimed in this case, that because they took no affirmative actions, they have not violated their waiver. But of course, everyone knows that violations can be undertaken by act or omission, and claimants had no right just to do nothing when they had a proceeding before the Court of El Salvador that was in violation of the waiver, which they could have and should have and had the obligation to discontinue. Thank you.
Mr. Malachuk, you have also the possibility for a short rebuttal.
Unless I didn't want to, excuse me. I did not want to leave on a note that somehow suggested that I give misinformation to this tribunal. In the very last paragraph, and you can see the website yourself, from a press release from Doing LeBoeuf, that they're representing the governments of Costa Rica, El Salvador, and Nicaragua in a lawsuit. I don't know how to display the whole article on the website, but that's the top part of it. And my information from this press release is that representation started within the last couple of months. So I leave it to you to decide what is the accurate information. But I'll scroll to the bottom. And that's all I have to say on it.